For many people, adoption is a route to becoming a parent, but it's also important to understand what it means and what is involved. Adoption is a permanent step, which gives the adoptive parent the same parental rights and responsibilities for a child that they would have if they were the biological parent. There are three main types of adoption: step-parent, where someone wishes to adopt their partner's children; full adoption, involving the placement of a child with the adopter through either a voluntary or local authority adoption agency; and overseas adoption, involving the placement of a child from another country. In all cases, it's important that the correct procedures are followed and the legal consequences understood. In a step-parent adoption, anyone wishing to adopt their partner's children should understand that whilst it will not affect your partner's legal rights and status, it will permanently extinguish the parenthood of any other parent the child has. It will also end their right to maintenance and inheritance from that parent. The child then acquires legal rights against you for maintenance and inheritance. You should also be aware that if your relationship with the birth parent were to end, your legal responsibility to your adopted child would continue. It will not normally be possible for a step-parent to adopt their step-child if the non-resident parent is still a part of that child's life, because the non-resident parent's consent would be required. Such a parent is often unwilling to give up their parental responsibility and legal relationship with their child. It will not normally be possible for a step-parent to adopt their step-child if the non-resident parent is still a part of that child's life, because the non-resident parent's consent would be required. Such a parent is often unwilling to give up their parental responsibility and legal relationship with their child. It is sometimes possible to apply to the court to dispense with the non-resident parent's consent, but it is important to take legal advice if you are considering taking that step. The importance of a child retaining as close a relationship with both birth parents as possible is well recognised by the courts and child development experts. But the court can still make an adoption order if the other parent can't be found or plays no part in the child's life, and it would be in the best interest of the child to make an adoption order. The procedure that must be followed is to first of all give notice in writing to your local authority of your intention to apply for adoption. You then apply to the court by completing a form A58, and sending it to the family court with the relevant documents and court fee. You must wait at least 3 months and no more than 2 years after giving your notice to the local authority before you apply to the court, and you must have lived with your child for at least 6 months. The process is usually straightforward where everyone agrees. Your local authority will appoint a social worker to investigate the case and prepare a report for the court, making a recommendation as to what is in the child's best interests. The court will then decide whether to make the adoption order. In the two other types of adoption situation, the procedure is different. In the case of a full UK adoption, adopters can be a couple or a single person. They must be at least 21 years old and domiciled and habitually resident in a part of the British Islands. To adopt a child, you can go through either an adoption agency that is part of your local council or a voluntary adoption agency. To start the process, you should contact the adoption agencies, who will then arrange to meet you, and if you and the agency agree to continue, you will be required to fill out an application form. Once the agency receives your application form, they will take a number of steps. They will invite you to a series of preparation classes. They will arrange for a social worker to visit you to prepare a home study assessment and arrange a police check. You will need to provide 3 referees to give you a personal reference and undergo a full medical examination. The social worker will prepare a prospective adopter's report and send it to an independent adoption panel, who will make a recommendation about your suitability to adopt a child. The agency then makes a final decision on whether to approve you as an adopter. Once you've been approved, the agency will begin the process of finding a child. Once a child is found, you are given complete information about the child. If you wish to proceed, an adoption placement report is prepared, which recommends whether to approve the match. The match will then need to be approved by the adoption panel and ratified by the agency's decision maker. Once this is approved, you and the child gradually get to know one another before the child moves in with you. You then need to apply to the court for an adoption order. The child must have been with you for at least 10 weeks before an application for an adoption order can be made. You will complete this application with the help of your adoption social worker. Once the application is made, the court will make some standard directions listing a hearing, asking for the local authority to file a report, and directing that the birth parents and others with parental responsibility file evidence if they wish to apply for leave to oppose the adoption. Sometimes birth parents will make an application to oppose the adoption, and the court will list the case for a contested hearing quickly. It is essential to take legal advice at that stage, as those cases can be extremely complicated. Sometimes birth parents will make an application to oppose the adoption, and the court will list a contested hearing quickly. It is essential to take legal advice at that stage, as these cases can be extremely complicated. I've also known cases where errors on the part of the local authority have placed the adopters in an extremely difficult position. If that happens, you need to act quickly to safeguard the prospects of a successful adoption. If there is no opposition to the adoption order, or if any attempts to oppose have been unsuccessful, then a hearing will be listed to make an adoption order. If all of the paperwork is correct, the court will generally make the adoption order at the first hearing. Once the adoption order is granted, the court will consider listing a celebratory hearing. Celebratory hearings are an event to celebrate the adoption where family and friends come to the courtroom. The court organises a certificate and present for the child, and the child's new birth certificate is issued. In the case of an overseas adoption, the procedure is similar to a domestic adoption. You can adopt a child from overseas if they can't be cared for in a safe environment in their own country, and the adoption would be in their best interests. In all cases, the adopter must be assessed as eligible and suitable to adopt from overseas by an adoption agency in the UK. Anyone wishing to adopt a child from overseas should first contact their local authority. You will have to undergo the same assessment and evaluation process as you would for a domestic adoption, and it's important that you must follow the correct procedure. Once you've been approved, the agency will begin the process of finding a child. In some countries, it's important that you do not try to identify a potential child before you reach this stage. How precisely the matching process works depends on your destination country and the rules that apply there. However, you will need to visit the child who you propose to adopt and engage with your adoption agency in the UK as things proceed. Depending on your destination country, you will either need to apply for adoption there or bring your child back to the UK to adopt them here. You will need to obtain a British passport or entry clearance authorising your child to enter the UK before you travel.